फ्रेंड्स वेलकम टू इम्पैक्टिंग क्वालिटी एजुकेशन फ्रेंड्स JTS 2023 रो आज फाइनल हियरिंग थिला एवं आज फाइनल हियरिंग रे बहुत पक्षर जो आर्गुमेंट थिला ता सुनिला परे कोर्ट तांकर फाइनल निष्पत्ति नैछंती एवं एही निष्पत्ति को वर्तमान आपण मानको सॉरी वर्तमान आपण मानको रिजर्व कोइ रखि निया दैछि एवं संरक्षित जाको कि आपण माने जानिथिबे संरक्षित कोइ रखा जाइछि एवं विदिन 2 वीक एहारो रिजल्ट पब्लिश करिवार सूचना मिलुछि एवं फ्रेंड्स आज आर्गुमेंट टोटाल 2 घंटार भी अधिक थिला एवं आपण माने ए वीडियो या परे कोर्ट रो प्रोसीडिंग देखिपारे आर्गुमेंट देखिपारे एवं निजे जानीपारे आज कोर्ट रूम रे कौन है तो फ्रेंड्स या परे आपण माने देखिपारे वर्तमान कोर्ट रो आर्गुमेंट वीडियो तो फ्रेंड्स देखिबा आगु जदि हम चैनल रे नुआ थिबे चैनल को सब्सक्राइब कर दियंतु एवं वीडियो को लाइक कर दियंतु चलंतु फ्रेंड्स स्टार्ट करिबा
category in Malkani district has secured 171. Yes. And my lord, the score of the last candidate of SCBC open category in category 2 science in the state is also 171.50. So not only does he qualify for what he had applied for, he does not fit into any other place in the state also, based on his marks. And there are Jittu Nayak, I need not read them, they are all of the same. Now, my lords, category 1. My lord, he has applied for category 1 and category 2. These are the two lists for the whole state. And obviously his name will not figure because he is not in the marks. It is nobody's case that we were a part of the list which was prepared post CBT and we have not been considered. Right? But I'll just trouble your lordship few more documents and then straight away I'll come to judgment. Yes. You know, this is just to demonstrate. So your lordship may see the first page is Nabarangpur. Nabarangpur, my lord. Yes. My lordships have it, my lords. Nabarangpur, as your lordship just saw, my lord, 167.315 was the last mark. Kindly see page 1. It has 21 numbers, my lords, page 1. Yes. Page 1, if your lordship sees, my lord, there are 21 candidates because Nabarangpur had 21 vacancies. Now the last one is 16.315, which your lordship just saw in that affidavit, and his score was 147. Now, if my lords kindly, and your lordship may see, my lords, in this list, at serial number 18, there is one Keonjhar. Right, my lords? There is one Keonjhar, 3 from the bottom. Yes. And he came into on the basis of merit. Now kindly see, my lords, what happens post the judgment. If I take all Nabarangpur, which is what I was told to do, to take it district-wise irrespective of the mark. Here also, if your lordship sees, my lords, post judgment, the last candidate secures 160.118. This is page 2. The last person in this list of Nabarangpur is 160.118. Now, two things happen.
So this is post judgment.
Grateful. Now, two things happen here. It drops from 167 to 160. Your Lordships had seen the previous page. The last candidate on merit had 167.325 marks, and here it is now dropping to 160, and here also he doesn't qualify.
No, but why this was there? Keonjhar and Mayurbhanj.
My lord, Mayurbhanj and Keorbhanj, they came because they were qualifying on the basis of merit. Am I clear, my lords? Because on merit they came into it.
They did not qualify their first preference.
They did not qualify their preference, but because of the marks they came here. Second preference was this place. Now the petitioner in the first one, he didn't even qualify because his mark was only 147. If your lordship looks at the next chart, which is based on only district preferences, as directed by the learned single judge.
So this can be a situation
Yes, my lords.
where this person, Keonjhar,
Yes, my lords.
he was not getting his
Keonjhar.
position in Keonjhar.
Keonjhar. So he came here.
His first preference.
I'm grateful.
But because of his merit position, he was qualifying
great.
as per his second.
Because he gave 29 districts, all 30. So he came here. Now, when I do the next exercise, post judgment, only on the basis of districts, forget merit. Kindly see, my lord, same 21 posts, all Nabarangpur. The first one is, my lord, let me go a little slow. Serial number is 1 to 21, same. Extreme left-hand side column, my lord. And then kindly see, my lord, application number, roll number, name of the candidate, father's name, etc., my lord. And kindly see the last column, marks in CVT. Now, district preference, first preference district. So now we are not going by the CBT. We are restricting it to districts. If your lordship sees that, the last person, serial number 21, he secures 160 marks. So therefore, if I were to take all district preferences, then 160 he doesn't fit in because he has got 147.48. So therefore, my lord, the consequence is this. People from other districts who are more qualified now go out of the list, and in any case, the petitioner does not fit in. I'll take your lordships to one more chart, and that your lordships will see. He also applied for Malkangiri, as I read to your lordships. Kindly see, my lord, page 3. Malkangiri, page 3, originally, my lords, the last cutoff mark is 171.500. That your lordships will get at page 3. And that will be, my lords, serial number 16.
Yes.
And my lord, your lordship will see 17 and 18 are persons with disabilities. So therefore, the last SCB mark was 171.500 and the petitioner had scored 150 marks. 150.5. So therefore, he does not get into this also. Now kindly turn over the page, minutes. Here now we are saying
for Malkangiri.
Yes, my lord.
And who got?
Grateful. I'm grateful. Now kindly turn over the page. We go for all Malkangiri. Now post judgment, I don't go by what marks you have secured. I will first give all first preference Malkangiri. Now my lord, here what happens, your lordship may see the previous page, the last mark was 171.500. Am I clear, my lords?
Yes.
Kindly turn over the page. Post judgment, the last mark goes to 144.617.
167.
I'm sorry, I'm grateful. My lord, 167, which is a drop of almost 27 marks. And the petitioner has secured 150.5. So your lordships will ask me, my lord, then why he is not there in the second list? Because he has gotten UR. Kindly see, my lords, the UR list is at page 5.
Page 5. Page 5. This is already published.
Yes, my lord, page 5 is UR for Malkangiri already published. My lords have it, my lords. And kindly see, my lords, page 8. My lords have page 8, my lords. So that is the end of that list.
Yes.
It has almost 79 candidates. So if your lordship sees, my lord, item serial number 79 at page 9, the cutoff is 175.904. My lordships have it. Last but one. This is the UR list for Malkangiri. His position is 79 and the cutoff mark is 175.904. Am I clear, minutes?
Yes.
Kindly now see what is the UR list post judgment. Post judgment. And if that list starts at page 9 and kindly turn to, my lords, page 13. Serial number 70.
Yes.
Now the petitioner is at page serial number 70. His mark is 150.5. This is post judgment. And if my lords are kindly pleased to turn over the page, my lords, page 14, the last mark of UAE, of UR is 147. So, my lord, it now drops from 175 to 147. 28 marks. And that is how he gets in. The submission to your lordship is this. Are the children not entitled?
No, that is not the question.
Yes, madam.
Advocate General, the question is,
yes, madam.
There can be two types of selection.
Correct. No difficulty.
One district-wise and the other combined. So if in the advertisement it is mentioned that the selection shall be district-wise,
yes, please.
so if the candidates are to apply against a particular district, or then probably the judgment may be correct. That because he had applied against that district, so his merit is to be considered against that district only. No, here is a combined competitive examination. A total merit list is to be prepared.
I'm grateful.
And thereafter, based on preferences,
I'm grateful.
They are to be allotted districts. And this is your submission.
And to add one more line, my lords, when he applied also, he gave a preference of 30 districts. Because he was also conscious that if I don't fit in one, I'll fit in one of the 30. But he would fill in one of the 30 if he qualifies in the test. If he is not there, if he is not there in the computer-based test list at all, then can he be considered for any district? That's the point.
No, every candidate who applied,
yes,
was entitled to be considered for all districts against which he had given preferences. First, second, third, or fourth.
Correct.
This is your...
provided he qualifies.
Yes, provided he qualifies,
yes.
He has to be considered for all the districts for which he had given preference.
Just a repetition of 30. Let's show me that page. page 40 of the writ petition. I don't know if the paper book will be with your lordships. Achhi ki?
Annexure 8.
978 writ petition. Achhi ki?
I got the copies. Can I pass on?
The writ petition we have.
Ah, yes. The annexes they have not given. It is with the annexes. If my lord want, I
Oh, annexure. अच्छा, writ तो नहीं है.
the writ petition I have.
You can see this one.
This is the writ petition I have got copy for my.
Writ appeal, this is the document my London Advocate General is signing.
This is part of writ appeal.
Yes, in the part of the writ petition, out of which this appeal arises. And kindly see page 40. Mismatch. This is annexure 3 series to the writ petition.
Yes.
Your Lordship may see, this is the candidate about whom we are discussing, Chintamani Bhuiya. Your Lordship may see application number on the right side is Chintamani Bhuiya. My Lordship's have it, minutes. Now let us see what he does. Father's name so and so, mother's name so and so. City preferences, Bhubaneswar, where he will give his exams. Bhubaneswar, Cuttack, Jagatsinghpur, Nayagarh. Kindly turn over the page. District preferences for joining. My Lordship's have it, minutes. So therefore, it is not his case that I only applied for one district.
Nabarangpur, he has given first preference.
First preference. I am grateful because he was aware that based on the CBT test, if he qualifies, he has to not give only one, he has to give several, and he gave all 30. So my submission to your Lordship is this. He has to first get into the CBT test qualification. After he is shortlisted, his district will be organized depending on his preferences. That's all. Now, my lord, I will show your Lordships a few judgments and I'm done. He can't do it. I'm sorry. This can't happen every time. My lord, Lordship may see. My lord, this was a case regarding filling up of medical posts. And this is 1968 to SCR 786. This is a Constitution Bench judgment once. So here, the allocation was something similar to us. There was a Rule 8 which said it will be district based. And kindly see paragraph 2 minutes at page 2 of the judgment. Your Lordship, I have paragraph 2. Rule 8, which is another rule under challenge, provides that the seats reserved in the general pool and seats reserved for the socially and educationally backward classes will be allocated among the various districts on the basis of ratio of population of each district to the population of the state. My Lordships have it based on districts. Now, my Lords may kindly turn to paragraph 9, which is at page 5, because they are dealing with the validity of this rule. Paragraph 9, my Lord. At page 5, my Lords have para 9.
Yes.
The next attack is on Rule 8, which provides for a district-wise distribution of seats according to the population of the district. This is attacked first on the ground that it violates Article 51. My Lord, I will not read this because they have not agreed with this attack. If my Lords kindly turn over the page, my Lords, they say 15 is not violated. Let me straight away go to para 10. My Lords have para 10, my Lord. In the alternative, it is urged that district-wise distribution violates Article 14 of the Constitution because it denies equality before the law or equal protection of the laws in as much as such allocation of seats may result in candidates of inferior caliber being selected in one district while the candidates of superior caliber cannot be selected in another district. Exactly what your Lordships are seeing in this case. Somebody with a higher mark is going out and somebody with a lower mark is getting in. Let me read further.
No, this can happen.
Yes, brother.
This can happen if you have one combined selection.
For one district.
No, for all the districts.
Correct.
You have combined selection.
Yes, madam.
But in the advertisement,
Yes,
you
madam.
point out
Yes, madam.
that you can apply against this district.
Correct.
One can apply against this district. Then the selection process for that district is confined to one selection process.
Correct.
Though your selection process
Correct.
is combined.
Correct.
So this can happen.
Yes, madam. Let me read further.
Yes.
Instead one reason so and so. It has not been denied on behalf of the state that such a thing cannot happen, though there are no statistics available in this behalf because the mark sheets were all destroyed after the interviews. Para 11. The question whether district-wise allocation is violative of Article 14 will depend on what is the object to be achieved in the matter of admission to medical colleges. Here, your lordship will read it, my lord, for
Yes.
selecting teachers to teach. The object of selection can only be to secure the best possible material for admissions to college, subject to the provision for socially and educationally backward classes. So this is the rider. Further, whether selection is from the social and educational backward classes or from the general pool, the object of selection must be to secure the best possible talent from the two sources. If that is the object, it must necessarily follow that the object would be defeated if seats are allocated by districts allocated district by district. It cannot be and has not been denied that the object of the selection is to secure the best possible talent from the two sources so that the country may have the best possible doctors. If that is the object, the argument on behalf of the petitioner appellant that it is the object cannot be possibly be served by allocation district-wise. It is true that Article 14 does not forbid classification, but classification has to be justified on the basis of the nexus between the classification and the object to be achieved, even assuming the territorial classification may be a reasonable classification. The fact, however, that the classification itself is reasonable is not enough to support it unless there is a nexus between the classification and the object to be achieved. Therefore, as the object to be achieved in a case of the kind with which we are concerned is to get the best talent for admission to professional colleges, the allocation of seats district-wise has no reasonable relation with the object to be achieved. If anything, such result will result in many cases in the object being destroyed, and if that is so, the classification, even if reasonable, would result in discrimination in as much as better qualified candidates from one district may be rejected, while less qualified candidates from other district may be admitted from their own two sources, from either of the two sources. So they have gone really one step forward, Willards, to say that such a rule also will be frowned upon. Kindly turn over the page, Willards.
Yes.
Lordship may see, Millard, there is one line which starts after 7-8 lines. We are also satisfied. 9th line, my lord. We are also satisfied. My lordship shall have that line. We are also satisfied that such allocation results in discrimination and there is no nexus between the territorial distribution and the object to be achieved, namely admission of the best talent from the two sources already indicated. We are therefore of the opinion that allocation of seats on the district-wise basis is violative of Article 14. We may add that we do not mean to say that territorial classification is always bad under all circumstances. But there is no doubt that district-wise classification, which is being justified on territorial basis, in these cases is violative of Article 14, for no justification worth the name in support of the classification has been made out. We therefore hold Rule 8 providing district-wise allocation is bad as it violates 14 and therefore we struck it. So they say that rule said district-wise. They said, look, you are looking for the best talent. So you can't say that district-wise or territorial-wise.
No, but this was whether on the basis of residence of a particular candidate.
Correct.
Here,
Yes.
a resident of Khurda
Yes, my lord. Could
give
apply
first
anyway.
preference,
Correct.
first preference
Yes.
for, say, Malkangiri.
Fair enough. But what they say is that when you are selecting a MBBS student, select the best talent. Don't restrict it to any district. Here I am saying that if I am selecting a teacher, the students of Malkangiri, Bolangir or Khordar, any matter, any district, they should have the facility of getting taught by the best. That is why you had a CBT exam, otherwise there was no reason. Number this is one. Kindly see one more judgment. Now this is Radheshyam Singh, where a zonal consideration was being considered. People were applied, so they said, okay, for A zone, these candidates. Kindly see para 2 minutes. May I see, Lordship, may kindly see para 3 at page 62. This is, my Lord, 1997, volume 1 SEC, page 60. And if my lords are graciously pleased, my lords, kindly turn to paragraph 3, my lords. My lords are para 3.
Yes.
According to this said advertisement, recruitments were to be made zone-wise on the basis of a separate merit list drawn from each zone in respect of the candidates who appeared at the centers within the same zone. The relevant portion of the said advertisement, which relates to zone-wise process of selection of candidates for the said post, as stated in para 16 of the advertisement, for ready reference is reproduced. Your Lordship may skip all that minutes and kindly come to paragraph 7. This is just above placitum H.
Yes.
The question therefore arises for consideration is whether such a selection based on zonal basis would be permissible or would it violate the constitutional guarantee enshrined under 14 and 16 of the Constitution of India? This is the question, my lord, the Honorable Supreme Court poses for itself. Now, paragraph 8. It is needless to emphasize that the purpose and object behind holding a recruitment examination is to select suitable and best candidates out of the lot, and such an object can only be achieved by making a common select list of successful candidates belonging to all zones. On the other hand, if zone-wise selection is made, then various candidates who appeared in some of the zones and secured more marks than those who secured from other zones would be deprived of their selection, resulting into great injustice and consequent discrimination. Thus, there can be said to exist no nexus between the aforesaid process of zone-wise selection and the object to be achieved, that is selection of the best candidates. That being so, the process of selection envisaged in para 16 of the advertisement in question and reproduced in the earlier part of the judgment would lead to discriminatory results, because adopting the said process, zone-wise selection would result in devaluation of merit at the selection examination by selecting a candidate having lesser marks over the meritorious candidate who has secured more marks, and consequently the rule of equal chance for equal marks would be violated. Such a process would only be against the principles enunciated in Article 14 and 16 of the Constitution, but it also result in heartburning and frustration amongst the young men of the country. The rule of equal opportunity, lordships have read it, and then I need not trouble your lordship. My lord, one more judgment and I'm done. My lord, this is 2021 4 SCC 542, and there is a concurring judgment.
Which volume?
My lord, this is 2021 volume 4 SCC 542.
Yes.
This is Saurav Yadav and others versus State of Uttar Pradesh. And if my lords are kindly pleased, this is Justice Bhatt's concurring judgment. And it is at page 590.
Yes.
Paragraph 38 and 39. The second view is thus neither based on the authoritative pronouncement of this court, nor does it lead to a situation where merit is given precedence. Subject to any permissible reservation, either social, vertical, special, opportunities to public employment and selection of candidates must purely be based on merit. Any selection which results in candidates getting selected against open general category with less merit than the other available candidates will certainly be opposed to the principle of equality. There can be special dispensations when it comes to candidates being considered against seats or quota meant for reserved categories, and in the theory, if it is possible that more meritorious candidates coming from open general category may not be selected. But the converse can never be true and will be opposed to the very basic principles which have all the while been accepted by this court. Any view or process of interpretation which will lead to incongruity, as highlighted earlier, must be rejected. The second view thus, not para 39, the second view thus will not only lead to irrational results, where more meritorious candidates may possibly get sidelined, as indicated above, but will of necessity result in acceptance of a postulate of open/general candidates or reserve candidates other than those coming within the vertical. So I am relying on the first line, and that's it, perhaps. I'm grateful to your lordships. Please.
Lordships, I guess we've been greatly benefited with the Honorable AG's argument. Not much to add except this, that which in fact fell from your Lordship's mouth also, is that this was never meant to be actually a district-wise or a residence-based recruitment.
See, there could have been two results. One, purely based on the merit for the entire state, based on preference also. And then that one merit list would have been bifurcated, divided, again based on preference. So there would be no difference between the first merit list, the candidates in the first merit list, and those selected, those divided, bifurcated from them based on preference, district-wise. Am I clear?
Lordships.
So only a separate merit list, like it's a kind of allocation to districts.
Lordships.
So one from one combined merit list, you are allocating, the state is allocating different districts.
Yes, and the I think one thing which I wanted to bring to your Lordship's notice is this, that each one of them was actually allowed to participate for each and every post, irrespective where it is placed. That's very important. All that it probably the state did, instead of state preferring, you are allocated this or that, allowed that you make your preference or your first or second preference wherever you want to be placed according to the marks that you secure. So state never wanted to do away with the merit issue. So that's very important, because when it happens, if it was completely district based, then in fact they would have also asked for a residence certificate or something. That was not at all the case here. So
no, residence was never the criteria.
Never the criteria.
Preference had some criteria.
And according to your preference, you do get allocated. That's all. But this preference was never meant to absolutely not allow people who are higher up in the merit to go away. Because as I last time also submitted, the extreme of that argument would be that only because I preferred, I'll get a seat even if I secure 0. But that's possibly not. And I think that would be a very compromising situation vis-a-vis the state, and state would vis-a-vis the districts, which state would never want to do. Especially want to maintain a particular standard of education throughout the state. That's all would be to look at the entire thing from that perspective. That's all I would add. Otherwise, everything has been covered by a honorable bench.
May I be permitted to supplement the Advocate General, sir? So I only supplement by some 2-3 judgments. But one thing, as your lordships pointed out, so far the merit of the case is concerned, in fact, on 10/9/2023, which was placed by the London Advocate General, the candidates will be selected on the basis of the marks secured on the CBT computer-based test examination. This was circulated, sir.
The notice, the advertisement was not contrary to any provision under the resolution.
On the reservation.
Under resolution.
Oh, yeah, resolution.
Resolution. So that the process which was adopted was not in conflict with
Yes, sir.
any
Yes.
provision under the resolution 8.2, 8.3,
Right, sir,
whatever.
right. Sir. So therefore, 8.2 read with this notice dated 10/9/2023 makes it very clear. The candidates will be selected on the basis of the marks secured in the CBT computer-based test examination. That's all. And the Lordship already read 8.2 and 8.3. What comes to my mind?
And the district-wise posts were not advertised.
No, sir. The according to my submission, yes, according to my submission, 8.2 is the preparation of the merit list through the computer-based test, and the allocation is 8.3, if I have correctly understood. And the what comes to our mind that here is a question of merit and the preference of the district. This comes to two things. I have brought two judgments. Here is a case. AI 2006 Supreme Court, I don't want to again further add something which the Advocate General already clarified to your lordships, and they have given also illustrations. And this judgment, if your lordship will come to where the merit and the preference is there, particularly which will be preferred. Lordship, look to paragraph 4. Paragraph 4. To appreciate the real controversy in perspective, it is necessary to notice the requisite qualification mentioned in the advertisement as per the requirement of Rule 8 of Uttar Pradesh Homeopathic Medical Service Rule 1990. These are the academic qualification, the entry, the recognized degree in homeopathic, that is the minimum qualification. But you also see the bottom. It will be noticed from the above quoted rules that in addition to the requisite qualification, a proviso has been added, inverted comma, preference will be given to the degree holders. The real controversy starts from the proviso that preference will be given to degree holders. Then also straightway come to the last but one page, the judgment in 2003 BB Commission versus YBBR Srinivasan that has been quoted. Let me read that quotation, then I'll take your lordship to paragraph 12. The word preference.
Which paragraph?
The paragraph 11.
11.
Just above paragraph 12.
Yes.
The quotation. The word preference, in our view, is capable of different sets of meaning, taking color from the context, purpose, and objects of use on the scheme of things envisaged. Hence, it is to be construed not in isolation but detached manner, ascribing a meaning of universal import for all contingencies capable of an invariable application. The procedure for selection in case involves a qualifying test, a written examination, an oral test or interview, and the final list of selection has to be made on the basis of the mark obtained in them. The suitability and all-around merit, it has to be adjudged in that manner only. That justification could be there for overriding all this merely because a particular candidate is in possession of an additional qualification on the basis of which a preference has also been envisaged. The rule do not provide for separate classification of those candidates or apply different norms of selection for them. The preference, inverted comma, envisaged in the rule, in our view, under the scheme of things and contextually, also cannot mean an absolute en bloc preference akin to reservation or separate and distinct method of selection for them alone. A mere rule of preference meant to give weightage to the additional qualification cannot be enforced as a rule of reservation or rule of complete precedence. Such a construction would not only undermine the scheme of selection envisaged through the Public Service Commission on the basis of merit performance, but also would work great hardship and injustice to those who possess and the required minimum educational qualification with which they are entitled to compete with those possessing additional qualification too, and demonstrate their superiority merit-wise and their suitability for the post. It is not to be viewed as a preferential right conferred even for taking up their claims for consideration. On the other hand, the preference emphasized has to be given only when the claim of all the candidates who are eligible are taken for consideration, and when anyone or more of them are found equally positioned by using an additional qualification is a titling factor in their favor vis-a-vis other in the matter of actual selection. In paragraph 12. In the instant case, the requisite academic qualification for the post of homeopathic as prescribed in the advertisement was recognized a degree in homeopathy or a recognized diploma in homeopathy. A proviso has been added that the preference will be given to the degree holders. This would mean that a recognized diploma in homeopathic prescribed in the advertisement is also a required minimum educational qualification with which they are entitled to compete with those candidates possessing the degree. The word preference would mean that when the claims of all candidates who are eligible and who possess the requisite educational qualification prescribed in the admission are taken for consideration, and when one or more of them are found equally positioned, only the additional qualification may be taken as a titling factor in favor of the candidate vis-a-vis others in a merit list prepared by the commission. But preference does not mean en bloc preference irrespective of inter-se merit and suitability. This is one. Another.
So there is difference between the preference which has been dealt with in this judgment and the preference in the present selection process.
Yes.
There the preference, the selection body gives,
Right.
the state
Because
gives.
of the
State gives that preference. Here, the preference is to be given by the candidate
Yes, sir.
for the purpose of allotment of a district.
Allotment
This
of
is
a
the
district.
difference between.
So-
But yes, the law, the crux remains that merit has to be given.
Merit has to be given. That is what my entire.
But the preference in this and preference.
My answer is absolutely correct. Absolutely correct. There the state has done it or the employer has done it. Here the candidate themselves have done it.
have to prefer.
Prefer.
They have 10 choices.
Yes, sir.
Which will you prefer?
Right, sir. Right. So now the question is, sir, the merit. Merit cannot be sacrificed. And I don't know, possibly it is for the state. So far 8-2 is concerned, they have prepared a list. So far as these 4 candidates who have approached this honorable court, whether their names at all found place in that merit list that was just prepared in terms of Rule 8-2, I don't think. And even if their names found place, even if their name must be below that list. So they cannot be compared to a person. But I just give an example. Suppose the district Khurda, there are only 10 posts and 30 candidates have given their preference to Khurda district. But it is the employer's duty, the state duty to give those candidates according to their preference. They will give the other candidates which cannot be accommodated as per their merit to other district. So therefore, under no circumstances merit can be sacrificed. The
No,
merit
there can be another example.
Sure.
I don't know the this thing in demography and the economic conditions, but suppose Kalahandi.
Yes, sir.
So for Kalahandi, the first preference is made by say 20 candidates only out of 1 lakh. So
Right.
can it be a situation that those 10 candidates will have to be selected for Kalahandi, whatever their performance is?
Absolutely right. Your also is correct. Correct. That is the position. Cannot. So therefore, the merit list cannot be ignored. So far as the post judgment is concerned, what they have prepared, I found these 4 candidates, even including the petition number 1, the private opposite party, they have secured the marks much below the marks secured in the last candidate in any other districts. So the category 2. So for the Malkan, in that case, if the honorable single judge judgment is accepted, that means a candidate who has secured 146 has to be selected, and a candidate who has secured 176 has to be ignored. That means in between 2, the merit has to be sacrificed. That is what another judgment I'm just giving. I post my argument. This is also 1989 Supreme Court page 1194, paragraph 14. I think your advocate general cited one judgment also that that's the intelligible indifferentia so far as this district is concerned. That paragraph 14. Let us now examine the question of college-wise institutional preference, paragraph 1400, from the point of view of Article 14 of the Constitution. By the impugned rule, a classification.
You are reading which paragraph?
Paragraph 14. Paragraph 14. 1-4.
Yes. Please.
Let us now examine the question of college-wide institutional preference from the point of view of Article 14 of the Constitution. By the impugned rule, a classification has been sought to be made with the students of each particular college passing their MBBS examination from that college to the exclusion of all other students obtaining their MBBS degree from the other colleges. In order that a classification is a permissible one within the meaning of Article 14 of the Constitution, two tests have to be satisfied. Namely, one, that there is an intelligible differential which distinguishes persons grouped together from those who are left out of the body. Sir, you also skip over to next page.
Yes.
Next page. The appellates who had come to this court were not parties to the writ petition. The High Court, while preparing its own list, did not think it fit to issue notices to other candidates like the appellant before this court, who has suffered prejudice by the regions of the directions issued by the High Court. By dealing with the justifiability of the same, this court held that they were necessary parties. In that context, expressed thus quotation. The procedural law as well as the substantive law both mandates that in the absence of a necessary party, the order passed is a nullity and does not have a binding effect. The other judgment I have already given. I did not take your lordship so much time. I will only give a memo of citation and I'll give to your lordship. That's my.
Yes.
The small petition for my lordship. Since learned advocate general and all other senior advocates, they have placed their submission. I'll not take much time of my lord's lord. Limit it to only 2-3 points.
So you come back within 2 minutes.
Right.